If you receive a notice of intended prosecution from the police asking you to identify the driver, then you must complete it and sign it and send it back within the required time period. This is not an admission of guilt to the offence, simply identifying the driver. The police will then go to that driver or come back to you if you've identified yourself, and that is the stage when legal advice will be required. The police, however, have to send the notice of intended prosecution to the registered keeper so that you could receive it within 14 days of the alleged offence. Well, there are a number of defences available. A commonly used defence is that you have used all reasonable diligence to ascertain who the driver was, but have been unable to do so. So, for example, there might be 3 regular users of the vehicle, you've checked your records, and none of you are able to say who was driving at the relevant time. It's a slightly different situation if it's a company vehicle, because the company have to keep records, but that defence still might be available. Also, it would be a defence if you'd never received the notice of intended prosecution asking for the identity of the driver from the police, or if you'd received it, completed it, sent it back, and the police simply never received it. If you can't identify the driver, the matter will go to trial, and you and all of the potential drivers will really need to demonstrate all the efforts you took to identify the driver, records, perhaps receipts from the bank of where you were on the day. You can't simply say we had a discussion and we can't say who the driver was. They will want more than that. But again, a solicitor will be able to advise you of the requirements.